about a damn thing if I was up in it.
Nod my head, don't close my eyes. Halfway on a slow mo.
Bridgeport, Connecticut, December 12th, 2021. A call comes in just after dawn for an unresponsive 23-year-old woman in a small apartment off Plymouth Street. Emergency medical personnel arrive. At 6:49 a.m., she is pronounced dead at the scene. Her name is Lauren Smith Fields. Weeks later, the state medical examiner will rule her death an accident, acute intoxication from fentanyl, promethazine, hydroxyzine, and alcohol. Years later, internal files and disciplinary records will show that Bridgeport police closed the case without telling her family. That sequence, death, ruling, closure, will ignite a push that becomes law in Connecticut, a 24-hour next-of-kin notification rule now written into the state's statutes. Tonight, we stay with the files, the timelines, and the words used on the record. No rumor, no leaps, only what's verified, attributed, and signed. Let's begin with Lauren, because names have weight. She's 23, a Stanford High School graduate living in Bridgeport, taking classes at Norwalk Community College. Local coverage at the time noted she also ran her own small business. She is a daughter, a sister, part of a close family that expects to see her for her 24th birthday within days. That birthday will be marked instead by a march to City Hall and a rally. The prior night, December 11th, 2021, Lauren is at home. According to a police incident report summary, reproduced in multiple local outlets, she spends the evening with a man she met on Bumble. The incident narrative, as relayed by the man and reflected in those summaries: drinking, a movie, Lauren becoming ill and vomiting, then resting. Around 3 a.m., he says he hears her snoring. When he wakes again around 6:30 a.m., he finds her unresponsive, notes blood around her nostril, and calls 911. Paramedics pronounce her at 6:49 a.m. The medic's estimate places the time of death at least an hour earlier. That's the official frame we can stand on for the overnight timeline. Two official moves define the next chapter. On January 24, 2022, the Connecticut Office of the Chief Medical Examiner rules Lauren's death an accident, acute intoxication due to the combined effects of fentanyl, promethazine, hydroxyzine, and alcohol. The next day, Bridgeport police announce the case is being handled as a criminal narcotics investigation by the department's Narcotics and Vice Division, with assistance from the DEA. That posture reflects how source tracing works in polysubstance fatalities. The medical ruling addresses manner and cause. Narcotics detectives and federal partners often try to backtrack supply. From the very start, Lauren's family will say their pain is compounded by process, by what they describe as the department's failure to notify them promptly and the tone of subsequent interactions. In interviews at the time, they say they learned of Lauren's death through a note on her door with a landlord's number more than 24 hours after she was found. They also say a detective told them to stop calling. City leaders will later acknowledge the department's handling of notifications fell short and order an internal affairs review. I'm being precise here. Those early claims come from family members, on camera and in print, and are cited in internal affairs documents and litigation filings. They are not my words. What did law enforcement do and not do? The department's official posture in 2022 is two-tracked. Detective Bureau and then Narcotics and Vice, with a public request for DEA assistance. No one is charged in relation to Lauren's death. The date who called 911 is publicly named by his attorney as Matthew LaFontine, and his lawyer says he cooperated with police for several hours on the day Lauren died. That lawyer's statement is the basis for the on-screen lower third phrasing. Again, clarity matters. Attorney says is exactly how we know it. Internal affairs is the other line. In 2024, Hearst, Connecticut reporters obtain and publish scathing internal summaries. Detectives failed to promptly and properly notify the families in the two separate deaths that occurred the same day: Lauren Smith Fields and Brenda Lee Rawls. One case file faults a lead investigator for not conducting a thorough investigation. And critically, records and a police spokesperson confirm that both death investigations had been closed more than a year earlier without the families being told. That is not conjecture. It's in the IA records and in Bridgeport's on-the-record comment. About the handling of evidence and timing, the public record contains two distinct sources. First, the federal civil complaint and the court's later order summarize the family's allegations, that certain items were not collected promptly and that an officer told relatives to stop calling. Allegations are allegations. The judge's order carefully notes it is deciding legal sufficiency, not fact-finding on the merits. Second, contemporaneous reporting in early 2022 compiled incident report details. What was said to be collected, what wasn't, and when, for the public timeline. Where these two sets overlap, I'm labeling one as alleged in court filings, the other as reported from incident summaries. That's our line to walk. The narcotics track deserves its own pause because people hear DEA and think arrests coming. In reality, source tracing in accidental overdose cases often ends quietly, with no charges tied to a single death. In March 2024, Bridgeport officials tell reporters the DEA-assisted investigation into Lauren's case is in the process of closing, with no arrests expected by June. That's not satisfying to hear if you love someone who's gone, but it is a common endpoint in intoxication rulings when police cannot link specific criminal conduct to the decedent's ingestion. The word closing here is theirs, not mine. Discipline and accountability. What happened to the detectives? The short answer, per records released in 2024 about disciplinary hearings held in 2022, is that the two detectives at the center of the notification failures lost 2 paid holidays. That sanction is a matter of record. It followed suspensions and an internal affairs process that unfolded under public pressure and mayoral statements calling the early handling unacceptable. Critics, including the family's attorney, called the punishment paltry. Document the sequence, quote the reactions, keep the verbs neutral. That's how we do this. But the file does not end at discipline. It moves into statute. In 2022, after testimony from the families and amid statewide debate, Connecticut enacts Public Act 2261, now codified at Connecticut General Statutes 7294 mm. This is Lauren's Law, though the statute's title is neutral. It requires peace officers to ensure next of kin are notified as soon as practicable and no later than 24 hours after identification. If notification isn't made within that window, the officer must document the reason and attempts. And a next of kin who wasn't notified may ask the State Office of the Inspector General to investigate the failure. This is the concrete, measurable change that advocacy produced, with an effective date of October 1, 2022. Departments across the state, Bridgeport included, have since published policies referencing the Inspector General backstop. Laws don't bring a person back. They do shape what the next family experiences. Let's return to the December night and stay exact. The man who called 911 told police they had been drinking tequila. He reported that Lauren went outside briefly after exchanging messages with someone she described as her brother, then was in the bathroom for 10 to 15 minutes, came back, fell asleep. He carried her to bed. He says he woke at around 3 a.m. and heard her snoring. At about 6:30 a.m., he found her unresponsive. All of this appears in incident report summaries quoted by reputable outlets. It's not a conclusion. It's a scene description attributed to him. It is also consistent with the state's later cause of death ruling, a mix of fentanyl, 2 antihistamines, and alcohol, and with the department's decision to focus narcotics detectives on supply questions. Documented times in toxicology remain fixed even when public feelings are not. Who was Lauren outside a case file? A daughter who traveled, who posted, who studied, a young woman building a business and a future. Her family and friends describe her as loving and close-knit. In the days after her death, vigils and marches formed around City Hall and through her neighborhood. Neighbors, activists, students, clergy, calling first for answers, then for policy. National outlets amplified the story. State leaders took notice. By late January 2022, the mayor had placed the detectives involved on leave pending internal affairs. None of that undoes the loss, but it explains the arc of attention that followed, a wave that helped carry the notification bill to the governor's desk. Litigation. In December 2023, Lauren's mother, Chantel Fields, filed a federal civil rights suit, Fields v. City of Bridgeport, alleging, among other counts, race discrimination and unequal treatment in how the police handled Lauren's death and the family's notifications. On February 20, 2025, U.S. District Judge Kari Dooley granted the city defendant's motion to dismiss, dismissing some claims with prejudice and others without prejudice, and allowing an opportunity to file a second amended complaint by March 24, 2025, with the case to be closed if no amendment was filed by March 25. The order is explicit that it is about legal sufficiency and does not resolve factual disputes about the investigation. That distinction matters. Court orders decide what can go forward as a claim. They do not certify what happened in an apartment at 3 a.m. Now, the piece that can be misunderstood, the presence of the DEA, the phrase criminal investigation, the conflation of that posture with a homicide probe. The department's January 25, 2022 statement opened a criminal narcotics investigation precisely because fentanyl was present. That is not the same thing as declaring or implying foul play in the lay sense. It's a supply chain question. And as reported in 2024, that line of inquiry was in the process of closing with no arrests expected. Words matter. Postures matter. Outcomes matter. We also need to separate what the family says from what Internal Affairs found. The family says critical items weren't collected promptly, that the scene wasn't properly processed, and that they were treated dismissively. The Internal Affairs records obtained by reporters found failures around notification, and in one case, a failure to properly investigate. Those are distinct statements with different authors and standards. One can be true alongside the other. One can be wider than the other. Our job here is to keep the labels on. Law and reform, briefly but precisely. Public Act 2261, now Track 7-294, requires police to ensure next of kin notification as soon as practicable and within 24 hours of identification, to document delays, and gives next of kin a right to ask the Inspector General to investigate failures. Agency policies, including Bridgeport's General Order 6.116, now reflect that if an officer fails to make the notification in the 24-hour window, the Inspector General will investigate. The law took effect October 1, 2022. That is the legacy written in ink. As for Matthew LaFountain, the public facts we can state are narrow. He called 911 around 6:30 a.m. after reporting he found Lauren unresponsive. He has not been charged, and his attorney says he cooperated with the police for several hours the day Lauren died. That's what the record supports. Nothing more, nothing less. Keep his lower third precise. Matthew LaFountain called 911. Not charged. Attorney says he cooperated. Where does it stand today? Officially, the medical ruling remains accidental acute intoxication. Bridgeport's posture, per records and statements reported in 2024, is that the death investigation was closed more than a year prior to those disclosures, and that the narcotics line was in the process of closing with no arrests expected. The federal suit saw significant claims dismissed in February 2025, with a window to replead some counts. If you're looking for new official movement in the last 3 months, there have been no new public case updates directly tied to Lauren's death. What remains are the human questions and the process lessons. Did the system move in a way that respected the family from the first contact? Internal Affairs says no, in plain terms, on notification and investigative thoroughness in one of the 2 deaths that day. Did public attention make a material difference? Yes. The statute is real. The 24-hour clock now starts the moment a person is identified, and there is an Inspector General backstop if it's missed. Did law enforcement publicly allege foul play? No. The medical examiner called it accidental. Narcotics detectives opened a source tracing probe. No one was charged. The department later closed the death investigation. Each of those clauses is anchored to an official statement or document, a word about dignity. Lauren's name has been said by her parents on Capitol screens and in City Hall foyers, held up by neighbors, carried on signs through winter air, and read aloud in committee rooms where the language of law was tuned to a family's worst day. The law will spare others the shock of finding out from a landlord or a note on a door. It will force clocks to be watched and reasons to be written. It will make someone accountable to call, to knock, to sit in a living room and say the words the right way. That isn't justice in the cosmic sense, and it isn't the answer to every question, but it is a line in the code that didn't exist before Lauren. That line is her legacy. So we end where we began, with timestamps and receipts. 6:49 a.m. Pronounced. January 24, 2022. Accidental acute intoxication. January 25, 2022. Narcotics and Vice, DEA assistance. 2024. Internal Affairs findings and public confirmation of case closure without family notification. Discipline equal to 2 paid holidays. October 1, 2022. Public Act 2261 in effect. The 24-hour rule. February 20, 2025. A federal order dismissing key claims, allowing a narrow path to amend. Dates alone do not tell a story, but they stop us from telling the wrong one. We hold to them, we attribute precisely, and we say her name correctly and completely, Lauren Smith Fields.